Welcome to Literal BS. Today we're tackling a fascinating and fundamental question about the bedrock of American law. Can the U.S. Constitution ever be removed? Or is it truly an immutable document protected from even the most powerful executive? Get ready for a deep dive into constitutional law, history, and political theory. When we talk about the Constitution being removed, what exactly do we mean? This isn't about someone physically picking up the document from the National Archives. We're talking about its legal force and supreme authority being nullified or replaced. What does removed mean in this context? It's not a physical act. It means the Constitution ceases to be the supreme law of the land. This could imply being completely replaced by a new constitution, being fundamentally altered to such an extent that its original purpose and structure are unrecognizable, being rendered irrelevant or ignored by all branches of government and the people. Though this scenario is less about removal and more about systemic collapse like it's happening today, and to understand how this could theoretically happen, we need to examine what the framers intended when they crafted our Constitution. The founders created what they envisioned as a living document, one that could adapt and grow with the nation, but not without serious deliberation and widespread consensus. They recognized that society would inevitably change over time, so they built in Article 5, the constitutional amendment process. This mechanism is central to any discussion about constitutional removal. Here's a helpful way to think about it. Imagine the Constitution as a house. You can renovate rooms, add new wings, or even demolish the entire structure and rebuild from the ground up, but only through a very specific, deliberately difficult process. What you absolutely cannot do is have a single person grab a sledgehammer and start swinging. The system simply doesn't work that way. This brings us to the heart of the matter. If constitutional removal were to happen legally, there's only one pathway: Article 5 and the amendment process. This is the sole legal and constitutional mechanism that could theoretically accomplish what we might call removal, though it's more accurate to say fundamental transformation or complete replacement. The process involves two distinct phases: how amendments get proposed and how they get ratified, each with two different methods. Now, here's the crucial distinction we need to make. While you can't simply delete the Constitution like a computer file, you could potentially replace it entirely or alter it so dramatically that it becomes something fundamentally different. The key word here is could, because the process is intentionally arduous. Let's break down exactly how this constitutional transformation would work in practice. So let's examine Article 5 itself, the constitutional roadmap for change. The framers made this process intentionally challenging, reflecting their commitment to governmental stability while still allowing for necessary evolution. The first and most familiar route runs through Congress, and it's worth noting that every single one of our 27 constitutional amendments has traveled this path. Here's how it works. Both the House and Senate must approve the proposed amendment by a 2/3 supermajority. Consider the political reality of this requirement for a moment. We regularly see Congress struggle to pass ordinary legislation with simple majorities. Imagine the extraordinary consensus needed to reach 2/3 in both chambers simultaneously. This isn't just about party politics, it demands broad, sustained agreement across ideological lines. History shows us this can happen, though rarely. The 19th Amendment, granting women the right to vote, and the 13th Amendment, abolishing slavery, both cleared these congressional hurdles, but only after extensive national debate and shifting public opinion. These weren't hasty decisions, they represented fundamental societal changes that had reached a tipping point. The second proposal method is far more mysterious and, frankly, more unsettling to many constitutional scholars. This route bypasses Congress entirely. 2/3 of state legislatures, that's 34 states, can demand a national constitutional convention. Here's what makes this pathway so intriguing and potentially dangerous. It's never been successfully used in American history, which means we're operating in largely uncharted legal territory. Unlike the controlled congressional process, a constitutional convention operates with much broader and arguably unlimited authority. Picture this scenario: 34 states call for a convention to address something specific, like campaign finance reform or congressional term limits. Sounds reasonable, right? But here's the constitutional wild card. Once the convention is in session, there's significant debate about whether the delegates could ignore their original mandate and propose something completely different. They might walk in planning to tinker with campaign finance and walk out having drafted an entirely new constitution. This is why some scholars call it the nuclear option of constitutional change. It's the one pathway that could theoretically sidestep all the normal checks and balances, potentially allowing a relatively small group of delegates to fundamentally reimagine American government. Once an amendment is proposed through either method, it still faces the ratification hurdle, and here we encounter the second rarely used pathway: Instead of state legislatures voting, 3/4 of the states can hold special ratification conventions with directly elected delegates. This approach has only happened once in our entire history, the 21st Amendment that ended prohibition. The reason it's so uncommon is telling. It's typically reserved for issues considered so momentous that they deserve a direct vote from the people rather than just their state representatives. It's democracy at its most direct, but also at its most unpredictable. Now, here's where theory meets reality in potentially dramatic fashion. Any amendment that successfully navigates this gauntlet, whether through the congressional route or the convention route, whether ratified by legislatures or special conventions, becomes constitutionally equivalent to the original document. There's no hierarchy of constitutional provisions. This means, hypothetically, that a sufficiently comprehensive amendment could rewrite everything. Picture an amendment that dismantles the presidency in favor of a parliamentary system, or one that eliminates the Bill of Rights. If such a proposal somehow achieved the required supermajorities, it would legally remove those fundamental aspects of our current constitution. But here's the crucial point: the very difficulty of this process is its greatest protection. We're talking about sustained, overwhelming consensus across party lines, geographic regions, and different levels of government. It's not just hard, it's designed to be nearly impossible except in cases of genuine national transformation. This brings us to perhaps the most important question for our current moment: can a president or any single executive simply tear up the Constitution? The answer is an emphatic no, and understanding why reveals the genius of our constitutional framework. The entire system rests on a foundation of divided power, what the framers called the separation of powers with checks and balances. This isn't just political theory, it's practical protection. The president enforces laws but cannot create or interpret them unilaterally. Congress makes laws and controls the purse strings. The courts interpret what the Constitution means and can strike down actions that violate it. Every president begins their term with a solemn oath to preserve, protect, and defend the Constitution, not to dismantle it. This isn't merely ceremonial, it's a legal commitment that creates accountability. Consider the power of judicial review established way back in Marbury versus Madison. When courts declare executive actions unconstitutional, those actions become legally void. A president cannot simply ignore court rulings without fundamentally breaking the system itself. Then there's Congress's ultimate weapon, impeachment. Any president who attempted to remove the Constitution would face immediate removal proceedings for high crimes and misdemeanors. This isn't theoretical, it's a concrete mechanism designed exactly for this scenario. But perhaps most importantly, the states and the people themselves serve as the final safeguard. States have their constitutional structures and wouldn't simply comply with federal constitutional destruction. The American people, ultimately the source of all governmental power, would resist any such attempt through every available means. For an executive to actually remove the Constitution unilaterally would require the complete collapse of democratic institutions, the rule of law, and the consent of the governed. At that point, we're not talking about legal constitutional removal, we're talking about revolution or a coup. The Constitution is protected not just by law, but by the very structure of American democracy itself. So here's where we land: the Constitution exists in a carefully constructed sweet spot. It can evolve through the demanding but legitimate amendment process we've outlined, but it's virtually bulletproof against unilateral destruction. The beauty of the system lies in this balance, flexible enough to grow with the nation through Article 5, yet robust enough to resist authoritarian impulses from any single branch of government. Those checks and balances aren't just constitutional theory gathering dust in law school textbooks, they're active, living protections that spring into action the moment anyone tries to overstep their bounds. What we're talking about is the difference between constitutional change and constitutional crisis. Change happens through consensus, debate, and the grueling supermajority requirements we've discussed. Crisis happens when someone tries to bypass that system entirely, and that's exactly what our constitutional framework is designed to prevent. As we wrap up today's deep dive, we've uncovered some crucial truths about our constitutional system. The question of whether the Constitution can be removed reveals two very different realities: the theoretical possibility of dramatic change through Article 5's rigorous amendment process, and the practical impossibility of arbitrary destruction by any single actor. What emerges from this analysis is a picture of remarkable constitutional engineering. The framers created a document that could adapt to an evolving nation while simultaneously protecting itself from those who might seek to destroy it. Through separation of powers, checks and balances, judicial review, and ultimately the sovereignty of the American people, the Constitution has built-in immune systems that activate whenever its survival is threatened. The genius isn't just in what the Constitution says, but in how it protects itself from those who would silence it entirely. And speaking of protection against those who would undermine truth and democracy, that brings us to the end of another episode where we've cut through the literal BS that too often clouds these critical conversations. We've tackled some heavy constitutional ground today, but here's what I want you to take away. Knowledge is power, and understanding how our system works is your best defense against those who would exploit confusion and fear. In times when everything feels uncertain, when headlines scream crisis and social media amplifies panic, remember that our constitutional framework has weathered storms before. It's designed to bend without breaking, to evolve without collapsing. But it only works when we, the people, stay informed and engaged. Don't let anyone, politician, pundit, or provocateur convince you that complexity means hopelessness or that understanding requires surrendering your agency. You have a voice, you have power, and you have the right to demand truth over BS. Keep questioning, keep learning, and keep holding those in power accountable. The Constitution isn't just a document, it's a living promise that depends on all of us to fulfill it. Until next time, this is Rob. Stay informed, stay engaged, and never stop fighting for the democracy you deserve.